I hope you all can hear me. So, yeah, I'm Faraz, Head of Wills and Probates and Trusts. I've got a brief overview of wills, including trusts and powers of attorney prepared for you today. Obviously, if you've got any questions concluding this presentation, feel free to just give me a shout or send me a message. That's fine. So can I ask, first of all, it's going to be interactive a little, can you put your hand up for anyone who has a will, firstly? Brilliant. Top marks, right? So it's more than half the room. So that's impressive. So for the ones who don't have a will, if you die without having a will, you become intestate. So meaning that you don't get to choose how your estate is distributed. Okay. So you don't get to call the shots, unfortunately. And what then happens is it follows what's called the rules of intestacy, which then the law governs who will then, number one, you appoint as your personal representatives. So instead of executors, it'd be personal representatives, and also who your estate then goes to in a particular order. Okay. So, is there any guesses for if you're a married man, you've been survived by your wife, who would inherit your estate if it was a intestate estate? Any guesses? Spouse. Yep. So yeah, you're right. But the problem you have is it won't entirely go to your spouse under the rules of intestacy. There's a proportion that goes to your spouse, which is the first 322,000. The rest is then split between the children and the spouse, which might not be ideal for inheritance tax planning, which we'll come on to talk about as well there. So the order generally is, it's a surviving spouse, civil partner, children, grandchildren, and if you don't have any of the above, then it's parents, and it drops down to siblings and other relatives. So you could, if you don't have a will and you don't have that immediate family, it could, a second cousin removed might inherit that you frankly don't like, or is quite well loaded himself. So yeah, so that's some of the important issues. Also, unmarried partners do not inherit under the intestacy rules, regardless of how long you've lived together with that unmarried partner. And another quite crucial one is stepchildren do not inherit automatically under the rules of intestacy. So again, if you want to make provision, because you might have had stepchildren from a baby, young age, and you've built a bond with them and you'd like them to inherit, so it's quite important there. So the basics of a will then, so for those who've got a will, great, excellent. But there's still some consideration to be made, because although you've got a will, does it still meet your objectives? Because there's things within a will you can include to further, include in your wishes as such. So the will allows you to choose who receives assets in what proportions, okay? You can, as I mentioned earlier, protection for unmarried partners. Instead of personal representatives, you get to choose who your executor and trustees are. So executor and trustees are people you appoint to deal with the estate, your estate, when you die. So in my experience of dealing with clients, a lot of the time when we send out a questionnaire, they'll bypass their spouse and they'll go straight to like adult children or a sibling, and then we usually expand on the question and say, well, are you aware that you can actually appoint your spouse as a executor and trustee on your death, together with your adult children or whoever it might be? And they kind of look at you, oh, I didn't realize you could do that, because they think, can an executor be a beneficiary? So that's why we advise to say, yes, an executor can also be a beneficiary. So that's an important point. The executors, in some sad occasions, you might not have anyone who can be the executor as a person. You might have a good friend or anyone like that. So you can appoint a professional executor, being a solicitor or a financial advisor. The benefits of appointing a solicitor is that you get the legal expertise and knowledge, will make sure the estate is dealt with appropriately, okay? And the downside is that obviously there will be cost consequences of the solicitors dealing with it, okay? So yeah, so if you've got any questions about that, by all means, you know, we can have a chat about that. In the will, you can appoint guardians, so children are, apart from your principal residence and other properties, your children are probably the most important thing to you. So within your will, you can appoint guardians to look after your children, okay? Inheritance tax planning. So are people, I'm sure because obviously you're landlords, you'll be aware of the basic threshold. So if anyone could shout out what the nil rate band, the threshold for the nil rate band is. Top man, good stuff. And then in addition, if you own a property, you also have what's called a residence nil rate band. Does anyone know what that is? Brilliant, perfect client. So when we get clients in, we do this estate planning. We'll explain to them as a married couple typically, they'll have their nil rate band of 325. If they own a property jointly, they'll have a residence nil rate band of 175. So collectively, they have £1 million threshold, which is, you know, obviously quite very helpful in their situation. Anything over the million is then subject to inheritance tax, which is at 40%, okay? Just looking on here. When it comes to tax, I believe gentleman Martin Wardell, who can advise you on tax, on the tax matters, but obviously you can pick whoever you like. But yeah, we do have Martin, who's will be very helpful in that instance. Because obviously, when it comes to estate planning, inheritance tax and such, we can advise to a certain point, but then when you're looking to look at the tax implications, you need to speak to a tax advisor because we're not regulated by the Financial Conduct Authority. So to expand on just a general will, what you can also include within the will are certain trusts, okay? So going back to a married couple, you own a principal residence, which is in your joint names, hopefully it's as tenants in common. So tenants in common means that you own the property equally, but you have your respective shares in the property, which is typically 50-50, okay? If you include a life interest trust, what it is written into your will, and it's dormant whilst both the married couple are alive, and the trust begins on death of the first spouse. So the deceased 50%, instead of it going to their spouse, it's ring-fenced for beneficiaries, i.e. children, grandchildren, whoever you would like, okay? So the surviving spouse can continue to live in the property undisturbed, so they can continue out their business, live in the property. If they want to downgrade, relocate, they can do that. So they just have to comply with the trusts such as that, continue paying the outgoings. They've also got to make sure the property's still in good repair, so on and so forth. So yeah. And the trust would then only come to an end if the surviving spouse dies himself, remarries or cohabits, so it protects you from remarriage or cohabitation, so at least the children would get 50%. And you're thinking, well, what else can this benefit me? So the big thing is about local authority care fees. So what we say is it protects at least 50% of your principal residence. So if you've got a £400,000 house, 200,000 is protected, okay? So if the surviving spouse goes into care, the local authority can't touch the deceased 50%. They'll assess the survivors at that point. But again, if you get tax advice at that point, they'll be able to let you know what exactly they can, you know, claw back as such. So that's fine. So within the will, so Davina made the point as well about, you know, what else can you include in the will? So you can include specific gifts. You can, if you've got, you know, provision for pets can be included in there. So if your pet's dear to you, which a lot of people love their pet, you can make provision for your pet in there. You can also include maintenance for the executors to pay out for anyone who looks after the pet as part of the gift. So funeral as well. So again, Davina mentioned funeral. So in regards to the funeral, it's actually the only part of the will which isn't legally enforceable. It's a wish or a desire. So a lot of people do get that confused. But you can put it in there black and white just to be certain that you've got it down somewhere. But our advice would always be to get a funeral plan in place, or at least let your executors know that you want to be cremated or buried, because various people have different belief systems. So as a Muslim, a burial is paramount. If I was being cremated, that would cause a stir in the family. But yeah, so that's the kind of things we would look at there. And then finally, the residuary estate. So that's the rest of your estate after all the assets, after all the liabilities have been paid, if there's a trust, whatever it might be. The residuary estate is the rest of your estate. So that could be anything from a penny to £1 million. You get to choose within your will who you want to inherit. It can be in shares, it can be in percentages. You can have backups. So typically for a married couple, it might look like something like on first death of the spouse, it'll be the surviving spouse. After that, it'll be children in equal shares, and after that, grandchildren. And again, you can then prescribe an age for children and grandchildren. You can say 18, 21, 25. You can also include a discretionary trust within your will. The discretionary trust is a trust where, give you an example, you've got a vulnerable, a disabled child, and it wouldn't be right for them to receive the inheritance in all one whack, and they won't be able to manage it because of their disability. What happens is the trustees you've appointed within your will, so going back to the executing trustees, they would manage that discretionary trust on behalf of that disabled child and drip feed them, so making sure that they're catered for. Okay, so that's why it's important you pick the right people, and that's the opportunity you're afforded when you do a will. You get to call the shots and make sure that happens. So that's fine. So I think in regards to wills, obviously, as I mentioned, it is paramount, and again, it's a light touch. If you do want to expand on it, I'm free to, you can email me, or we can have a chat after today's meeting. Okay. So a lot of people think, right, that's the end of the story. I've got my will. Don't have to think about anything further. Sadly, no. There's also what we call powers of attorney. So have people heard of powers of attorney? Yeah? Okay, brilliant. So there used to be what's called enduring powers of attorney. So you might have that in place. If you have that, no need to worry. It's still valid. However, there's a different process. So if you're unsure, again, you can contact a solicitor. We can walk you through that. Enduring powers of attorney actually only cover you for financial and property affairs. Okay. So if you're looking to do a health and welfare power of attorney, then you need to do the new, what we call lasting powers of attorney. Okay. So there's two types, as I just mentioned. There's one for financial and property affairs, and the other one is for health and welfare. Because we have quite a few landlords in the house, I've got some examples why you might want to do a property and financial one. So you can have a personal property and financial LPA, which will deal with your personal things, such as your bank accounts and personal matters. Typically, the ones who have powers of attorney in place already may be familiar that you appoint what we call attorneys. Okay, so attorneys are just people that you trust. It's not the American term for like a solicitor. It's an attorney, just someone you trust. So again, it could be a spouse, it could be adult children, it could be a good friend, someone like that. Okay. Typically, I would say appoint, one attorney and one backup or replacement, or you could pick two main attorneys. If you pick two main attorneys, they have the option to act what's called jointly and severally, or jointly only. Jointly and severally simply means that they can act either independently or together. So if one of your attorneys is on holiday, the other one who's free can then deal with your affairs. Fine. And the other benefit of jointly and severally is one sadly passes, the other one can continue to do the job for you and your piece of business that you require. If you choose jointly only, what that means is the attorneys have to be present at the same time, so that whether it be on a phone call, dealing with your banking, or going to the bank. So that could be logistically an issue. So, and you think, well, why would you do that? Well, you want them to act unanimously, you know. And then the other thing being, if you've got a kind of more inexperienced attorney, to be guided by, you know, the one who's older and has more experience. So that's the benefits of doing that. So the property and financial LPA for landlords then, it says it's particularly valuable because rental properties often require ongoing management and financial decisions. So if a landlord loses mental capacity without an LPA in place, essential property matters can be delayed until a deputy is appointed by court of protection. So that's the other thing. If you don't have a power of attorney in place and you've lost capacity, then you have to do the more complex application, which is what's called court of protection, which can cost a lot more, and it can also take a lot longer. So it's always, put in place precautions rather than act after the fact. The benefit of LPA for landlords is continued management of rental properties, sale or transfer of investment properties. So if you need to sell a property to pay for care fees, one of your properties, you might have multiple properties, you can fund the care fees, reduce financial liabilities, and deal with implementing financial planning. Your attorneys can deal with repairs and maintenance. So I'm sure and compliance with landlord obligations. So the attorney can help ensure compliance with gas safety, electrical safety, building insurance renewals, license requirements, etc. They can also manage bank accounts, which is similar to the personal account of your portfolio. They can deal with that on your business side, pay mortgages, pay service charges, ground rent, and such. And finally, they can work with letting agents. So instruct, oversee letting agents, approve tenancy agreements, and negotiate renewals. So I'm sure you as landlords, you're more versed than me when it comes to the landlord side of things. But yeah, you get the idea that you can delegate these tasks out, okay?
Can I just ask what happens if the properties are in a limited company?
If the property's so if it's a limited company, right, okay, so will you be... So again, the complexity of a limited company, will it be shareholding and will...
Let's say one of the director shareholders.
Yeah, director shareholders. I'd have to look into that. I don't know the answer right away, but there will be ways around it, yeah. And you would obviously provide that in your initial instructions, and we'll be able to look into that for you, yeah. But a good question.